I come to you this evening in the name of my Lord Jesus Christ. He's the reason that I'm here. He's the reason why I can stand before you. He's the reason that I know truth and that the truth has set me free, as it has you. And I pray that all who listen to this would hear truth and that it would set us free. Are you an abolitionist? Are you an abolitionist? There's a lot of people here saying, yes, I am. There may be some people hearing this saying, no, I'm not. Or there may be some people saying, I'm not sure if I am. Tell me a little bit more about what that means. Great, well, I'm glad you asked. Now, although abolitionism is about much more than what I'm going to get into this evening, in terms of the abortion-related bills that we support or that we oppose, what does it mean to be an abolitionist? That's what I'm going to be talking about. And if you're wondering that, I have 3 questions for you. Number 1, do you believe that the Supreme Court should overturn Roe v. Wade? Number 2, do you believe that a fetus is a person? And number 3, really? Do you actually believe those things? In other words, do you act consistent with what you say you believe? Well, if you answered yes to all 3 of those, then congratulations, at least as it relates to the bills that you support and oppose, you're an abolitionist. You may not know it yet. From a public policy perspective, being an abolitionist is not complicated. It's not very complicated at all. It's very simple. It means that you believe that Roe v. Wade is unconstitutional, that a fetus is a person, and that you act consistent with those beliefs. That's what it means. Let me flesh that out. Let me flesh that out some more. I'm going to do a brief summary of each of those, and then I'm going to do a deep dive into each of those. On the first question, do you believe that the Supreme Court should overturn Roe v. Wade? That's a very simple question that pretty much every single pro-life person, almost every single Republican is going to answer, yes, of course I do. Of course I believe the Supreme Court should overturn Roe v. Wade. That's why I've been voting Republican my whole life, right? That's why I even vote for the lesser of 2 evils and hold my nose, because I believe and I want the Supreme Court to overturn Roe v. Wade. So that's why I vote for anybody with an R next to their name. Good. Well, some of that's good. But it's good that you believe that the Supreme Court should overturn Roe v. Wade. That's good. That's good. They should overturn Roe v. Wade, right? They should do that. Why should they do that? Why should the Supreme Court overturn Roe v. Wade? Well, it's evil. Well, yes, it is. But, I mean, from a legal perspective, I'm an attorney. I speak from a legal perspective and a biblical perspective, I hope. But from a legal perspective, why should they overturn Roe v. Wade? Because it's unconstitutional, right? Because it's illegal. It violates the law, the higher law, the Constitution. You have to say that it's unconstitutional. If you think the Supreme Court should overturn Roe v. Wade, you have to say it's unconstitutional. Otherwise, why would they overturn it? If you're saying that, oh no, it is constitutional, but they should still overturn it, then you're saying that they should violate the law. So if you're a Republican, you're a pro-lifer, and you say, yes, the Supreme Court should overturn Roe v. Wade, then you have to say, because it's unconstitutional. Because it's unconstitutional. That's why they should do that. You have to say that it's unconstitutional. You have to say that when Roe v. Wade came down in 1973, it violated the law. It broke the law. It broke the Constitution, which is the law of the land. And then my question now is, if Roe v. Wade is unconstitutional, why have we been following it for 48 years? Why have we been following it for 48 years? What is the law of the land in this country? Of course, God's law is the law of the land. But as far as man's law is concerned, what is the law of the land? It's the U.S. Constitution that the states have ratified. And it even says that in the Constitution. The Supremacy Clause says, this Constitution and the laws which shall be made in pursuance thereof shall be the supreme law of the land. Well, Roe versus Wade was not made pursuant to the Constitution. We just said it's unconstitutional. Well, if it's unconstitutional, then it's not the law of the land. See, this is just a very simple logic here. Everybody's saying, like, yes. It's like, no, I'm not saying anything complicated. If you want it overturned, it's because it's unconstitutional. If it's unconstitutional, it's not the law of the land. And if it's not the law of the land, then states are not bound by it, right? And if the states are not bound by it, then we should support legislation that ignores Roe and treats it as not being the law of the land, and we should oppose legislation that legitimizes Roe versus Wade and treats it like it's legal. And I just told you about abolitionism. That's part of what it means to be an abolitionist, because that's what we do. So if you believe the Supreme Court should overturn Roe, the logical conclusion of that, the inescapable conclusion of that, is that you believe states right now can ignore it because it's not the law of the land. That's what an abolitionist does. Well, Bradley, you're defying authority. No one's saying anything about defying authority. They're the ones defying authority. They're the ones defying authority. The Constitution is the authority. And they're the ones defying it. Roe is not authority. I am not for defying lawful authority, but I am for defying tyrannical usurpation. I am for defying that. Where the court ignores the Constitution, we must ignore the court, lest we give legitimacy to tyranny. So on the second question, do you believe that a fetus is a person? Again, almost every pro-life person has to say yes to that. Almost every Republican has to say yes to that. Of course, I use the term fetus as shorthand to refer to all pre-birth stages of development. And when I use the term person, I don't mean some abstract term. I mean a human being like you and me, made in the image of God. So do you believe that a fetus is a person? Yes. Yes. Right? I think every pro-life person would say yes to that. They've been saying that for 48 years. They've been saying Roe should be overturned for 48 years. They've been saying the fetus is a person for 48 years. We're not here to say something new in that respect. We're simply here to say, okay, now act on that. Right? If you believe that a fetus is a person, then you must also believe that they should be treated as a person. That a person should be treated as being equal under the law, whether they're born or whether they're not yet born. If you don't believe in treating them the same, whether they're born or not yet born, newsflash, you don't really believe that they're a person. You don't really believe that they're a person then. In this country, prior to the Civil War, there are a number of southern states that had laws on the books that provided a different system of justice for people who were slaves and even for free persons of color, as it said in the penal codes of the time. I'm from Texas. In our Texas Penal Code, the Part 3 of the Penal Code is entitled, "Of the Offenses," that is, the crimes, "of slaves and free persons of color." That's the name of Part 3 of the Texas Penal Code of 1857. Why? And you know what it says in there? It starts with, it says, slaves and free persons of color are persons. It actually starts out by saying that they're persons. But then it says, but because of their peculiar position, essentially they get a different system of justice than everybody else. If they commit a crime, you can brand them on the face with the letter C. Oh, but you can't do that to a free white person. They get a different system of justice. This is even before the Civil War. But hey, we said they're persons. It's not enough to say it. It's not enough to say it. You have to act on it. The laws have to treat them as equal. Otherwise, what good is it? What good is it? You have to treat them as equal under the law with other persons. If you don't treat them as equal under the law, then you don't really believe that they're persons. And we did that prior to the Civil War, and we do that today with the fetus. That we do that with a preborn child. The 14th Amendment to the U.S. Constitution says, no state shall deny to any person within its jurisdiction the equal protection of the laws. That's what the 14th Amendment says because of what I just described states were doing prior to the Civil War. That's how we got the 14th Amendment. It says, no state shall deny to any person within its jurisdiction the equal protection of the laws. I was in Texas, and we were arguing for our Republican Party platform to support equal protection for preborn children from the moment of fertilization. And my brother J.R. Haas was there, and he was on the committee advocating for the preborn, advocating for equal protection of the laws, and got the language on there. And then someone moved to strike the words equal protection, saying we should take care of the preborn, but not equal protection. Because he knew what it meant. He knew the logical conclusion of what that phrase means. And to him, and to most, that's not pro-life. Equal protection is not pro-life. I'll talk about that more in a minute. So he moved to strike that phrase. And JR said, well, hold on. I'm confused. And I'm paraphrasing. I'm confused. You're wanting to strike the phrase equal protection for people before they're born, from the moment of fertilization. You want to strike the phrase equal protection. But the 14th Amendment says, no state shall deny to any person within its jurisdiction the equal protection of the laws. So are you saying that we should violate the Constitution? Or are you saying that they're not persons? Which is it? And this man, who was a pro-life leader in Texas, he said, I withdraw my amendment. And on the platform of Texas and legislative priority, it says equal protection in our party platform. So if you believe that a fetus is a person, then the logical conclusion of that, if you actually believe it sincerely, is that they must be provided the equal protection of the laws. So do you still believe the Supreme Court should overturn Roe? Do you still believe that a fetus is a person? Well, pro-life leaders have been saying these things for 48 years, but most of them don't believe them. Most of them don't believe the things they've been saying. Pro-life leaders have been saying these things. Republicans have been saying these things for decades. And I am a Republican. But most of them don't believe them. Most of them don't believe that a fetus is a person and that Roe should be overturned. They don't believe them because they're not acting consistent with them. If you continue to say these things, that Roe should be overturned and a fetus is a person, but then you oppose bills of abolition and you support bills that compromise on those things, then you don't really believe them either, to be frank. You don't really believe what you're saying. You don't really believe the Supreme Court should overturn Roe. You don't really believe a fetus is a person because you don't act consistent with those things. Because actions speak louder than words. Bradley, you're wrong. I do believe, I'm sorry, I can't hear you. I can't hear you because your actions are so loud. And they're loudly saying that Roe is the law of the land. And they're loudly saying that a fetus is not a person. That's what your actions are saying. When you oppose bills of abolition, when you support bills that compromise on it, that a fetus is a person. Guess what? Pilate had lots of nice things to say about Jesus. Remember that? He said he's a king. He said he's innocent. He said lots of nice things. but he authorizes crucifixion. His actions are what we judge him by. God doesn't judge us by our words alone. Jesus says, not everyone who says to me, Lord, Lord, shall enter the kingdom of heaven, but he who does the will of my Father in heaven. Jesus said in Matthew 7. What we say is important, but it's what we do that matters far more. What we say is only matters to the extent it's consistent with what we do. And don't accuse me of saying that anyone who opposes an abolition bill isn't a Christian. Okay? I'm not saying that. God will judge their heart, not me. We all make mistakes. We've all made mistakes. God is patient and gracious. He has been with me. We should be with others. But that doesn't mean that we shy away from the truth. What I'm saying is that if our words have said one thing, but our actions have said another, then we need to repent. We need to repent. We need to repent of lying to ourselves. We need to be consistent. What we say needs to be consistent with what we do. That's what it means to be an abolitionist, to be consistent with what we say we believe. Hey, I'm with you, Bradley. Okay, good. Tell me more about what these things mean. What does ignore row mean? What does equal protection mean? Tell me more. Let's do a deep dive into those things. When we talk about nullification or when we talk about ignore row, really you could describe it in a more positive way, and that is follow the Constitution. Follow the Constitution. That's what we're talking about. How did we get where we are? In 1965, the Supreme Court issued a decision called Griswold versus Connecticut. It was deciding the issue of contraception and whether states could outlaw methods of contraception. And in that decision, which most people have never heard of, a very important thing happened. And from that decision, we got a so-called right to an abortion. And from that decision, we've gotten a so-called right to homosexual relations. And from that decision, we've gotten a so-called right to homosexual marriage. Have all come from and cited Griswold versus Connecticut. So what's important about that decision? How did it lead to these other evils in our land? Because in that decision, the Supreme Court said that there's a right that before then none of us had really seen before, that no one really knew was in the Constitution. But the Supreme Court said, oh, no, it's sort of there. They said that there's a right to privacy in the Constitution. Now, of course, there are rights to privacy in the Constitution, the right to be free from unreasonable search and seizure, except based upon a warrant, based upon probable cause. There's a right to be free from the government quartering troops in your house, things like that are rights of privacy, or rights that relate to privacy. But there is no general right to privacy in the Constitution, and it doesn't take very long to think about why that would be problematic, because then you could justify pretty much anything as long as you do it in private, right? It's like, hey, government, stay out of my house. It's like, well, you murdered your husband in there. It's like, hey, privacy, right to privacy, right? I mean, a general right to privacy would be ridiculous. Yeah, kind of like where we are today, because they found this general right to privacy. They created this general right to privacy, but they say that they found it. They actually admit they didn't find it in the Constitution. They actually found it in the penumbra of the Constitution. In the penumbra of the Constitution. I had to look that one up. But in the penumbra, what is a penumbra? A penumbra is a shadow, right? So it's like they said, there's the Constitution, and then there's the shadow of the Constitution. But actually, a shadow is not called a penumbra. It's called an umbra. What's the penumbra then? Well, you see that kind of hazy, fuzzy shadow on the outside of the main shadow? Well, that's the penumbra. So this is straight from go read it. Go read the decision. Griswold versus Connecticut, 1965. They said that there's a right to privacy, and yeah, it's not in the Constitution. It's not even a direct shadow of the Constitution. It's in the penumbra of the Constitution. In fact, it's in the emanations of the Constitution. That if you just look just right, you can kind of see it, kind of twinkling there. That's where this right to privacy is. Okay. Well, then 8 years later, Roe versus Wade came along. And the Supreme Court said, oh, well, of course there's a right to an abortion. It's in the right to privacy. That's in the penumbra of the umbra of the Constitution. Yeah, that's what they said. You know, could they have done our job any more for us? They told us it's not in the Constitution, right? They told us it's unconstitutional. It's not in there. And yet we treat it like it is. The 14th Amendment says, like I said, no state shall deny to any person within its jurisdiction the equal protection of the laws. Not only may we abolish abortion, but we must abolish abortion according to our own Constitution. We must provide equal protection to all persons. And if you believe a fetus is a person, then you have to agree that we must. And the 10th Amendment says that all powers not delegated to the federal government are left to the states and the people. Well, where do we delegate to the federal government the power to compel states to allow prenatal homicide, to allow prenatal genocide? Where do we delegate that to the federal government? Where did we create a right to an abortion that states cannot outlaw that form of homicide? We didn't, which means that states still have the power, called the police power, to outlaw homicide, to outlaw abortion, because we've not delegated to the federal government. I'm trying to show you that not only is a right to abortion not in the Constitution, but the opposite is. That is, the Constitution protects the right to life from the moment of fertilization. States are free. States are free to follow the Constitution and to ignore Roe. The Supremacy Clause, as I discussed earlier, said, this Constitution, the laws which shall be made in pursuance thereof shall be the supreme law of the land. Was Roe made pursuant to the Constitution? Obviously not. The court itself said this is not in the Constitution. It's in the penumbra of it. Well, yeah, someone once told Thomas Jefferson, well, you got to read between the lines. And he said, oh, I've read between the lines. All I see is blank space. Okay? If it's not in the text, it's not in there. So only laws made pursuant to the Constitution are the supreme law of the land. Roe versus Wade is not pursuant to the Constitution. Therefore, it's not the supreme law of the land. Some people then say, well, what about Marbury versus Madison? Well, that's a Supreme Court decision from very early on in our republic. Or some people say that the court said that the court has the exclusive authority to say what the Constitution is and means, and everybody else has to submit to it. But it doesn't actually say that. But that's what people say it says. You know who says it says that? The Supreme Court. Funny. So actually, according to the Supreme Court, you can't ignore Roe. So I guess that's the end of the discussion. Or wait, no, I thought we had something higher than the Supreme Court. Oh yeah, the Constitution. But in Marbury versus Madison, I digress. Listen to this. This is a lengthy quote. I'm just going to read you this. Marbury versus Madison, a Supreme Court decision written by Chief Justice John Marshall, says, it is apparent that the framers of the Constitution contemplated that instrument as a rule for the government of courts as well as of the legislature. Why otherwise does it direct the judges to take an oath to support it? This oath certainly applies in an especial manner to their conduct and their official character. How immoral to impose it on them if they were to be used as the instruments and the knowing instruments for violating what they swear to support. The oath of office, too, imposed by the legislature is completely demonstrative of the legislative opinion on the subject. It is in these words, quote, I do solemnly swear that I will administer justice without respect to persons and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge all the duties incumbent on me as according to the best of my abilities and understanding, agreeably to the Constitution and laws of the United States. Continuing with Marbury versus Madison. Why does a judge swear to discharge his duties agreeably to the Constitution of the United States if that Constitution forms no rule for his government? If it is closed upon him and cannot be inspected by him? If such be the real state of things, this is worse than solemn mockery. To prescribe or to take this oath becomes equally a crime. It is also not entirely unworthy of observation that in declaring what shall be the supreme law of the land, the Constitution itself is first mentioned, and not the laws of the United States generally, but those only which shall be made in pursuance of the Constitution have that rank. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument, that is, the Constitution. Did you hear that? A law repugnant to the Constitution is void. That's what the Supreme Court said. And if a law is void, guess what else? A Supreme Court opinion is also void if it's repugnant to the Constitution. Void means it's not law. You don't have to follow it. Some people say, well, Bradley, wait a second. What about the Civil War? I thought the Civil War, you're talking about nullification. You're talking about nullification. That's what led to the Civil War, like the South did. Well, yes and no. You got your history a little backwards there, actually. It wasn't the South that was nullifying. It was actually the North. Go read, I was a history major. I love history. Go read the primary source documents. If you really want to know the truth, get out of history books. They're boring anyway. Go read the primary source documents and read the actual declarations of causes for why they seceded, why the various southern states seceded. I was looking at Texas just recently, and it says, quote, this is the Texas Secession Declaration of Causes, 1861, February 2nd. Here's why we seceded. The states of Maine, Vermont, New Hampshire, Connecticut, Rhode Island, Massachusetts, New York, Pennsylvania, Ohio, Wisconsin, Michigan, and Iowa, by solemn legislative enactments, have deliberately, directly or indirectly, violated the third clause of the second section of the fourth article of the federal Constitution and laws passed in pursuance thereof, thereby annulling, and I'll tell you what that is in a minute, thereby annulling a material provision of the compact designed by its framers to perpetuate amity, friendliness, between the members of the Confederacy and to secure the rights of the slaveholding states in their domestic institutions. I'll continue on from that in just a minute. But did you hear that? You hear that long list of states that Texas is complaining, the pre-Civil War Texas, is complaining that these states have nullified. And did you hear what they actually had nullified? They actually nullified the actual Constitution itself. Because a section of the Constitution itself said, we agree that slaves which escape to the North will be returned to their owners in the South. It didn't say it in those words, but that's what it says. That's what the third clause of the second section of the fourth article that they didn't really maybe want to spell out, but that's what it says. So the northern states were actually, they were nullifying. They were nullifying the actual text of the Constitution because there's a higher law. In fact, Texas is actually going to complain about the higher law in just a second. Let me keep reading this. This is good. Continuing from the Texas Secession Declaration of Causes. In all the non-slaveholding states, in violation of that good faith and comity which should exist between entirely distinct nations, The people have formed themselves into a great sectional party, Republican Party, now strong enough in numbers to control the affairs of each of those states, based upon the unnatural feeling of hostility to these southern states and their beneficent and patriarchal system of African slavery, proclaiming the debasing doctrine of the equality of all men, irrespective of race or color, a doctrine at war with nature, in opposition to the experience of mankind, and in violation of the plainest revelations of the divine law. God help us. They demand the abolition of Negro slavery throughout the Confederacy, the recognition of political equality between the white and the Negro races, and avow their determination to press on their crusade against us so long as a Negro slave remains in these states. All right, you go, abolitionists. For years past, this abolition organization has been actively sowing the seeds of discord through the Union and has rendered the federal Congress the arena for spreading firebrands and hatred between the slaveholding and non-slaveholding states. One day the pro-abortion people are going to be writing these things about us. I love it. By consolidating their strength, they have placed the slaveholding states in a hopeless minority in the federal Congress and rendered representation of no avail in protecting Southern rights against their exactions and encroachments. They have proclaimed and at the ballot box sustained the revolutionary doctrine that there is a higher law, if they put in quotes, than the Constitution and laws of our federal union, and virtually that they will disregard their oaths and trample upon our rights. They have for years past encouraged and sustained lawless organizations to steal our slaves and prevent their recapture. Anyways, go read these things. There's so much in there that, first of all, it's very eye-opening. Secondly, it's like, wow, that sounds very familiar. No, it was the northern states that were nullifying. The southern states seceded because the North was nullifying. Jefferson Davis, who was a U.S. Senator and became the President of the Confederate States of America, whenever he resigned from the U.S. Senate, he said essentially, I'm not going to read you his quote just to save time here, but he said essentially, we are seceding because the northern states are nullifying. That's what he said. Because they were willing to nullify even the Constitution itself if it violated God's law. We're not even willing to nullify a Supreme Court opinion if it violates the Constitution itself, much less God's law. Not yet, anyway. Not yet. Someday. You know, some people say, well, Brad, is the Constitution just dead? I mean, in some ways it is. But that which is dead can live again. There are some states that have actually codified, that is, they've put into written statute the death of the Constitution. Kansas is one of those states. Missouri is one of those states. Both of them have a law that says this, quoting from Missouri, the laws of this state shall be interpreted and construed to acknowledge on behalf of the unborn child at every stage of development all the rights, privileges, and immunities available to other persons, citizens, and residents of this state. So far, so good. Subject only to the Constitution of the United States. Okay. Subject only to the Constitution of the United States and decisional interpretations thereof by the United States Supreme Court. I'm sorry? You just elevated decisional interpretations of 5 unelected people to be equal with the Constitution ratified by all 50 states, by our representatives who are elected by us? And you just put that into your law, Kansas? You just put that into your law, Missouri? You've just said that the Supreme Court really is the law of the land, because whatever they say about the Constitution goes. So really, we don't even need a Constitution. We just do whatever the Supreme Court says is now in Kansas and Missouri law. That's why I was so grateful here a couple years ago when now Senator Mike Moon from Missouri let me draft a bill for Missouri, the Abolition of Abortion in Missouri Act. And guess what I wanted to, guess which statute I wanted to strike? That one. That one. And now he's introduced it again this year as a senator in Missouri. Grateful for Senator Mike Moon there. In some states, the Constitution is dead. Some states treat it like dead. Other states are still trying to enforce it on some issues. In Arizona, actually their Constitution itself, that they adopted this in 2014, it says the Constitution of the United States is the supreme law of the land to which all government, state, and federal is subject. To protect the people's freedom and to preserve the checks and balances of the United States Constitution, this state may exercise its sovereign authority to restrict the actions of its personnel and the use of its financial resources to purposes that are consistent with the Constitution. If the people or their representatives exercise their authority pursuant to this section, this state and all political subdivisions, counties and cities of this state, are prohibited from using any personnel or financial resources to enforce, administer, or cooperate with a designated federal action or program. Sounds good. Pursuant to the sovereign authority of the state, they then passed a statute based upon that constitutional amendment. Pursuant to the sovereign authority of this state and Article 2, Section 3, Constitution of Arizona that I just read to you, this state and all political subdivisions of the state are prohibited from using any personnel or financial resources to enforce, administer, or cooperate with the Affordable Care Act. The state of Arizona nullified federal law for the Affordable Care Act, what commonly called Obamacare, right? And they were right to do so. They were within their constitutional powers to do so. And good on them for doing so. And there are many states today on a different issue are nullifying by allowing people to grow and manufacture and to sell marijuana across the country. There are states that are, because it's against federal law to do those things. Grow, manufacture, distribute, sell marijuana. That's a violation of federal law to do those things. And yet states across the country, even this state, have passed laws that said, no, you can do that in our state. Wait, but that violates federal law. Yeah, but we're just treating that as null and void. We're nullifying that. Wait a second. Are you saying that even in Republican states, that we're willing to nullify for a plant, but we're not willing to nullify for a person? No, Bradley, it's actually worse than that. We're willing to nullify for our own pleasure, but we're not willing to nullify for the sake of someone else's life, their personhood, their humanity, their very existence. You see our priorities. I believe that the threat of nullification, the threat of states standing up and following the Constitution is actually what will lead the Supreme Court to overturn Roe versus Wade. Because I do want them to overturn Roe versus Wade. They should overturn it, but we shouldn't wait for them to overturn it. It's void now. It was unconstitutional in 1973. We should have ignored it then. We should ignore it now. But should they overturn it? Of course they should. Of course they should. And I believe what will lead them to do it is states saying, whether you overturn it or not, we're going to follow the Constitution. We're going to overturn it. And exercising their constitutional power. And then I believe that very well could be what causes the Supreme Court to say, you know what, if they do that and get away with it, then we're going to look powerless. Because they are powerless. And so we're going to overturn it ourselves. Otherwise, we're going to look like a paper tiger. Okay. Bradley, I'm with you so far. Now, what do we mean by equal protection? What do we mean when we say equal protection? What does it mean that a bill of abolition provides equal protection for preborn people? Of course, the two words equal protection are just shorthand for equal protection of the laws. Because, we're humans, we're finite. You can't actually equally protect people, right? You can try, you can do your best, but we're finite. But what we can do perfectly in a sense, is we can provide equal protection of the laws. Our laws can provide equal protection. Our laws can be free of discrimination. And that's what we're to do. And that's what an abolition bill is about. It's about changing the law. So equal protection of the laws means that the same laws that apply to protect people from homicide before they are born would also protect people from homicide. The same laws that protect people from homicide after they're born would also apply to protect people from homicide before they're born. That's all equal protection is. That's all it is. The main part of an abolition bill doesn't create any new laws. We're not writing new laws. We're simply taking the laws that already exist that make homicide a crime, homicide of born people, and we take away the exception for abortion. So that way it's now illegal to commit homicide of people whether they're born or not. And some people who oppose abolition, anti-abolitionists, they say, well, you're criminalizing the mother. I'm sorry, where is that in the bill? Who are we? We're not criminalizing people. We're criminalizing conduct. We're criminalizing actions. And I don't care who commits the action. Mother, father, abortionist, nurse, friend who drives you there, someone who pays for it, whoever it is. We're not singling anybody out. Anyone who participates or solicits or performs or procures an abortion or aids or abets that should be equally subject to the law. The law should equally restrain them from committing homicide. That's what a bill of abolition does. It doesn't single anyone out. We're not criminalizing mothers. We're criminalizing the conduct of people who commit homicide. We don't single anyone out. It applies to everyone equally. I had a man came up to me one time, he messaged me, and he said, hey, I'll support that abolition bill once it applies to the father, too. And I said, well, then sign the petition. Because it applies to everyone. Everyone. And he did. Because he saw, you know what, it does. That's all that a bill of abolition does. It just takes away the exception. The exception says the homicide code doesn't apply to you if you're not yet born. We just strike that out. To where the homicide code now does apply to you, even if you're not yet born. What does equal protection mean? Does equal protection mean that every single person who has anything to do with an abortion will be all getting the death penalty? That's not what it means. It's not about equality of outcome, okay, that everyone, from the person who has the smallest involvement to the abortionist who's killed, tens of thousands, that all of them had the exact same outcome. What equal protection is about ensuring the equal protection of the laws. See, it's the role of the legislature to write laws, to legislate, to lawmake, to pass laws, and to do so impartially, to pass laws that do not discriminate, that provide equal protection to everyone. That's what the role of the legislature is. When people bring up sympathetic cases and things like that, you say, whoa, wait a second. You're getting ahead of us. We're not even to that yet. We're talking about what should the law be. You're talking about individual cases. What you're talking about is our justice system. How should our justice system weigh those individual cases? And I agree that they should be weighed, and every case should be considered on a case-by-case basis, and not everyone should get the same outcome. I absolutely agree with that. But the law should equally protect everyone. And no one should have a license to kill. What does our justice system look like? I had some people ask me one time, they're like, I support the abolition bill, but this equal protection, I've heard some nasty things about that. Tell me what that means. And I said, well, here's how that would play out. And at the end of it, they're like, wow, that's eye-opening. So I'm going to tell you what I told them. Here's the way our system of justice works. Here's the way the justice system works. And the justice system is made up of people from both the executive and the judicial branches, are part of our system of justice. And what I'm about to describe generally applies to every state. Some states may be a little bit different, but mostly this applies to every state. How would a case work, right? If you pass a bill of abolition, what would a case look like, whether it be for a mother or whether it be for an abortionist or whether it be for the father who, pays for it or pressures the mother or what have you? What would the case look like after a bill of abolition is passed? Well, it would look like homicide looks right now. how we treat homicide right now in our justice system. See, it starts with a report being made to law enforcement, whether it be city police, whether it be sheriffs, or whether it be state police. A report is made, and then law enforcement decides whether to investigate. Is this worthy of investigating? And they have discretion to do that. They don't have to investigate every case. And they exercise that discretion. And maybe they then say, you know what, we aren't going to investigate. And then nothing happens. Or maybe they say, we are going to investigate. And then they conduct their investigation. Then maybe they get warrants, that have to be approved by a magistrate, normally a justice of the peace, that's to approve a warrant for them to be able to get access to medical records and various evidence. And they collect evidence, they talk to people, they do interviews. And finally, they put all that evidence together, and they take it to the prosecutor, and they say, do you want to charge this person? Do you want us to go arrest this person? The prosecutor at that point has what's called prosecutorial discretion, which is really absolute. They can say, even if I think this person's committed a crime, they can say, no, I don't want to prosecute this person. But the prosecutor then says, okay, what am I going to do with this? I can decide not to prosecute, or I can decide to prosecute, or I can do something else. I can say, I have grounds to prosecute, but I'm going to go to that suspect and say, I could prosecute you, but instead, if you're willing to testify against someone else, against a co-conspirator, then I'll give you immunity. If you testify against them, I'll give you immunity, so that way you can't be prosecuted. Prosecutors could do that. Prosecutors could do that in this case. In every bill of abolition, we allow, there's that, because that's what the law already is for born people, right? And all a bill of abolition is applies it to people before they're born. So prosecutors could grant immunity if you testify against somebody else. Then, let's say the prosecutor decides, no, I'm going to move forward with this prosecution. Well, we're talking about homicide. We're talking about felony. So at that point, in most states, the prosecutor is either required or very much, is incentivized to take that case to get someone else to charge the suspect. And that's called a grand jury. The grand jury is people from the community, either selected virtually at random or appointed. And those people sit and they meet and they hear cases. The prosecutor comes and brings them a case and says, here's what we say happened, here's what the evidence is, do you want to indict, which is called issuing a true bill, or do you want to no bill, which is refuse to indict this person. The grand jury can even decide, well, we want to call witnesses, and we want to hear evidence. We want to give the suspect an opportunity to be heard. The grand jury can do all those things. But at the end of all that, at the end of its deliberations, the grand jury, which it deliberates in secret, no prosecutor in the room. In fact, I've interned in the district attorney's office. There's a little light on there, and you're with the district attorney sitting on the outside. And when the light comes on, you can come back in the room. But in the meantime, they're deliberating, and you can't go in there. It's secret. So they deliberate, and they decide, no, we don't want to indict someone. Or they decide, we do want to indict someone. If they say we do want to indict, then it's on to the next phase of our justice system, which is the pretrial phase. And that's where the judge determines, was the investigation conducted in accordance with the law? Was it done constitutionally? And then, if all the law has been followed, then we'll have a trial. And at the trial, there will be another jury that's selected from the community, also at random, or at least the jury pool is selected at random, and then it's narrowed down based upon our laws, and the various parties have strikes and things like that, and you narrow it down to a jury of your peers to hear the case. The judge then oversees it to make sure that the law is followed, and the prosecutor presents his side of the case, or his or her side of the case, and then the defendant has an attorney. And if the defendant cannot afford an attorney, one will be provided to them by us, we the people, will provide them an attorney to make sure they have good representation or adequate representation in court. Competent representation is the phrase. So that attorney will then represent them. And in fact, if that attorney is incompetent and they lose, they actually get a new trial. But if they have competent representation, then they get the trial. And at the end of the trial, as long as the law is followed, then the judge will submit the case to the jury, which will then also go into another room and deliberate in secret. And they will deliberate about the evidence that's been put before them. And they will decide, number one, they'll decide, is this person guilty or not guilty, beyond a reasonable doubt, which is the highest standard in our law. Are they guilty do I believe beyond a reasonable doubt that they are guilty? Now, what are they guilty of? Maybe the prosecutors put forward several options. Maybe the prosecutors put forward capital murder, or maybe first degree, or manslaughter, or criminally negligent homicide, or maybe assault, or maybe just disorderly conduct. Prosecutors can do that. They can choose to charge you with disorderly conduct, which is one of the lowest misdemeanors, even for a murder. If they just want to get the conviction and they don't think they could prove the murder, but they can prove this. Right? They can charge you with something lower if they want to. So the jury decides all that and decides, is this person guilty or not? What are they guilty of? Comes back, turns it into the judge. The judge decides whether that's, make sure, is that against the great weight of the evidence? I'm getting into detail here, but with a point. And then the judge will say, as long as it's not against the great weight of the evidence, the judge will issue a judgment consistent with the verdict of the jury. But we're not done, because then the jury, perhaps even a new jury, will then decide sentencing. And now the prosecutor will now put on evidence of aggravating circumstances. This person's committed multiple crimes before. This person's a horrible person. This person, hates puppies and things like that. And then the defense attorney will also put on mitigating evidence and say, well, this is this person's very first crime. This person is nice to puppies. This person is, here's all these people from the community who love them. They say, and here's this person, they get on the stand and they plead and they're weeping and they say, I'll never do this again. And then the jury then goes back in secret again and they decide what to sentence this person for. And sometimes they may actually feel sorry for this person. They may say, we're going to sentence you to 1 day and $1. Sometimes that happens. It's like, you are guilty, but we feel really bad for you, so we're not going to give you a very light sentence. Juries sometimes do that. Or they can choose anything between that and whatever the highest penalty in that state is. In many states, it's the death penalty. In many states, it's not. That's what the jury can do, and then sentence that person. Then from there, the judge issues a judgment in accordance with that sentence. From there, you then have an automatic mandatory appeal to the next appellate court, or to the appellate court. There'll be multiple judges that will consider the case, make sure that, again, that the case is not against the great weight of the evidence, make sure that the law was followed. And if there were some issues with the law, because, not every case is perfect, but as long as there weren't issues that would cause the case to have been unjust, then, hey, they'll affirm what the jury did. Then from there, if you're convicted of a high enough felony, you have an automatic appeal, or at least you have an option to appeal to the highest criminal court in the state, the Supreme Court of your state, if you will. Who will then consider all the same stuff again, make sure that the law has been followed, all of the above again. And actually, you get to do with all that again through what's called habeas proceedings. I'm not going to get too far into detail, but let's just put it this way. There's lots of appeals. And the worse your sentence is, the more appeals you get. It's kind of a layman's way of describing what happens in this process, which is why, as I'm sure you've noticed, it takes a long time for justice to be carried out for people who commit crimes. But it's not over yet. You can actually sometimes appeal, in some cases, to the federal courts and then go through all that. But it's still not over, because even at the end of all that, if everyone has agreed up to this point that the conviction is just and the sentence is just, even the governor can change all of that. Because that defendant may submit a request to the Commission on Pardons and say, please pardon me, Mr. Governor, or Mrs. Governor, please pardon me. And then the governor will decide whether to pardon that person or whether to commute their sentence, which is lessen their sentence. The governor has almost absolute power to do that. In some cases, absolute power to do that. That is our justice system. That is our justice system. A bill of abolition just says that that's what every case should go through. It's not saying equal outcomes for every single case, no matter, it's saying, no, that justice system that protects born people and provides due process for born people, that justice system should apply to people before they're born too. And you know what else I didn't mention in that justice system is that there are things called defenses. There are things called justifications. Because people say, Bradley, what about, let me tell you some stories. I know a mom I've heard of a mom, I've heard from a friend that there's a mom who was forced to get an abortion. Well, guess what? That's called duress. And there's a defense of duress in the law, and it's in every bill of abolition, that a mother who's forced to commit a crime under threat of death or serious bodily injury is not guilty of a crime, right? If you're forced to do something, then you're not a criminal. Well, what about a miscarriage? That's an accident. That's not a crime. It's not a homicide. Not a single bill of abolition would criminalize anything close to that or allow for the investigation even of that. Well, what about a mom who really just doesn't know what she's doing? Well, those are getting fewer and far between because of science and because of lots of things. But if that truly did exist, that's called mistake of fact. And that mom would be able to put that on as a defense to say, you shouldn't hold me guilty because of this. And if it were true, she would be not guilty. Well, Bradley, what about medical situations like ectopic pregnancies where the mother's life is in danger? Well, that would fall under what's called the justification of necessity. And that is when you have a situation that is technically illegal, but you're in a situation where you have to weigh lives and triage care, then we're not saying that then under our criminal law, it's not illegal. And not a single bill of abolition would criminalize that kind of medical procedure. Triaging the care, as long as the doctor sought to save both of them, right? Both of them. As long as the doctor does everything the doctor can to save them both, then no crime has been committed. And that's in every bill of abolition. So, some mothers are victims, right? Some mothers really are victims. Some mothers are perpetrators. The law should provide equal protection so that our justice system can examine each situation on a case-by-case basis, just like we do with homicide of born people. That's all equal protection is. That's all it is. Why is that so hard for some pro-life people to accept? Why is that so hard? Unless you don't really believe that a fetus is a person. How do we, you know what? This is actually how we got Roe versus Wade in the first place. This is why we lost Roe versus Wade. Do you know this? This is why we lost Roe versus Wade. This is why the pro-life movement has been losing ever since Roe versus Wade. Bradley, that's a bold claim. It's not just my opinion. It's not just speculation. Look at our pre-Roe laws before Roe versus Wade, before 1973. Go look at the pre-Roe laws. Guess what? Immunity for mothers, exceptions, and the penalty for committing an abortion was way lower than the penalty for killing a born person. There was not equal protection even before Roe versus Wade in our country. And that's how we got Roe versus Wade, because we were not treating a fetus like a person. And so the Supreme Court just called us on that. Just said, I'm just going to follow your logic here. I'm not going to listen to your words. I'm going to look at your actions. And I'm just going to follow your logic. And this isn't just speculation. There were actually two sets of oral arguments before the Supreme Court in Roe versus Wade. Sarah Weddington represented Roe, the mother seeking an abortion. And in oral arguments, first set, she said, quote, these statutes, that is the statutes that outlawed abortion in the states, speaking specifically about Texas, because that was where Roe versus Wade came from, to our shame. These statutes were adopted for the health of the mother, she says. She's saying these statutes weren't to protect fetuses. These statutes were adopted to protect the health of the mother. Continuing, quoting from her, certainly the Texas courts have referred to the woman as being the victim. And they've never referred to anyone else as being the victim. I think it's important to realize that in Texas, self-abortion is no crime, she says. In other words, self-induced abortion. The woman is guilty of no crime, she says, even though she seeks out the doctor, even though she consents, even though she participates, even though she pays for the procedure, she again is guilty of no crime whatsoever. It's also interesting that in our statutes, the penalty for the offense of abortion depends on whether or not the consent of the woman was obtained prior to the procedure. It's double if you don't get her consent. There is no indication in Fondren versus State, a Texas case, for example, the court ruled that a woman who commits an abortion on herself is guilty of no crime. Again, she being regarded as the victim rather than the perpetrator of the crime. Obviously, in our state, the offense is not murder. It is an abortion, which carries a significantly lesser offense. That was the argument of Roe. And she got to argue it again a year later. As we talked last time, quoting from Sarah Weddington, they, the mothers, are not subject in Texas to any kind of criminal prosecution, whether the mother performs self-abortion, whether she goes to a doctor, finds someone who will perform it on her. She's guilty of no crime whatsoever, and yet the state tries to allege that its purpose in the statute was to protect the fetus. If that's true, the fact the woman is guilty of no crime is not a reasonable kind of, it does not reasonably follow. It's a transcript. You hear that? She says, Texas tries to allege that its purpose in the statute was to protect the fetus. If that's true, the fact that woman is guilty of no crime does not reasonably follow. If you're really trying to protect the fetus, why do you allow mothers to kill their own children with impunity? Well, then Texas Assistant Attorney General Robert Flowers got up, and Justice Byron White said, this is the justice, if you're correct that the fetus is a person, then I don't suppose you'd have, the state would have great trouble permitting an abortion, wouldn't it? Flowers, the Assistant Attorney General, yes, sir. Justice White, in any circumstance, Flowers, it would, yes, sir. And then Flowers continued, and we feel that the concept of a fetus, being within the concept of a person within the framework of the United States Constitution and the Texas Constitution, is an extremely fundamental thing. And then Justice Stewart says, of course, if you're right about that, you can sit down. You've won your case. An acceptance of that, of ours, may be the Texas abortion law presently goes too far in allowing abortion. Did you hear that? The Supreme Court justice who ruled against them, who ruled against Texas, who created this right to an abortion, Justice Stewart said, if a fetus is a person, your own law goes too far in allowing abortion because it doesn't provide equal protection. And this isn't just an oral argument. This is in Roe versus Wade, the opinion itself. Quote from the Roe versus Wade majority opinion, there are other inconsistencies between 14th Amendment status, that is, as a person, and the typical abortion statute. It has already been pointed out that in Texas, the woman is not a principal or an accomplice with respect to an abortion upon her. If the fetus is a person, why is the woman not a principal or an accomplice? That's what the Supreme Court said. That's what the majority opinion said. If the fetus is a person, why is the woman not a principal or an accomplice? Further, the penalty for criminal abortion is significantly less than the maximum penalty for murder. If the fetus is a person, may the penalties be different? That's what the U.S. Supreme Court said. If the fetus is a person, may the penalties be different? You see, we've denied equal protection, not since 1973, but for decades, in some states, for a century before 1973, for various reasons. But whatever the reason, it was unjust. And that's how we got Roe versus Wade in the first place. And because we've refused to learn the lesson that the Supreme Court told us right there in the opinion is the reason that they ruled against us, we've refused to learn that lesson. We continue to say in the pro-life movement, mother's a victim, she's not a principal or an accomplice, there should be different penalties. We've continued to deny equal protection ever since. Before Roe, even before Roe, our laws treated the preborn as subhuman. And since Roe, our laws have treated the preborn child as subhuman. And before and since Roe, pro-life bills that are introduced, even this year in this state, treat the preborn like they are subhuman. And we wonder why we haven't abolished abortion. Even though we've introduced thousands of pro-life laws, even though we've had thousands of court cases, we still haven't abolished abortion. As long as the laws we propose and support deny equal protection to preborn humans, we will deny their humanity and we will never abolish abortion. It will never be abolished. So, if there is equal protection, is it possible through that justice system that a mother could be arrested, that she could be tried, that she could be convicted, that she could be sentenced, that she could even be sentenced to capital punishment in states that provide it? Yes, it is. Yes, it is possible. But let me say two things on that. First, if she is, it will be because, as we discussed, that the entire justice system, from the law enforcement officer who first investigates all the way through to the governor who declines to pardon, are convinced by the facts of her case that her actions merit her conviction and merit that sentence. And they have to almost unanimously agree with that. The second thing I want to say is this. Does it shock you that a mother who hires someone to kill her child or does it herself could be tried by our justice system? Does that shock you? It shocks the pro-life leaders. Every time someone says anything like that, you know what they say? They say, that's not pro-life. It's abolitionist. Do you say, no, a mother should not be tried? Does that very idea repulse you? Then I ask you, where are you? Are you right now standing at your Capitol opposing the justice system that protects you? Are you demanding that the justice system protecting you be torn down? Are you at your state capitol right now demanding that a class of people be given a license to kill you, to take your life with impunity, to give legal immunity to your would-be murderer? Where are you doing these things? If you're going to be consistent, if everyone who commits murder is a victim, then why aren't you saying that, oh, okay, wait a second. No, I get it. I've seen this before. Laws for protecting me, but not for thee. Laws protecting me, but not to protect thee. How privileged you are to stand in the security of a justice system protecting your life and to deny that justice system to others just because they're different than you. Hear a lot about privilege these days? Well, I'm here to tell you what we have a lot of in this country and in the Republican Party and in the pro-life movement. Born privilege. Born privilege. We've got born privilege. It's so easy to fall into that. It's a bias we all have, and we're guilty of to some extent. But if it affects you to such an extent that you want to deny to another person the equal protection of the laws that protect you, then you do not really believe that they're a person. You do not really believe that they are created equal. You do not really believe that they are made in the image of God like you. No, that's just a privilege that you get to enjoy, for which you did nothing to earn. You were born. Congratulations, you made it. Now you get equal protection. But you want to deny it to those who are not as privileged as you, because you don't really believe they're persons. Listen, I mentioned privilege. I mentioned born privilege. We are privileged. We are privileged to have been born. You know what? Privileges are blessings, right? I was blessed to be born. Privileges are blessings. We shouldn't be ashamed of it. I'm not ashamed that I was born. I'm not ashamed of it. I should not be ashamed of that. There's a concept that says, with privilege comes obligation. Or to put it biblically, to whom much is given, much is required. As I tell this to my children, sometimes someone will be bullying somebody else. And I'll say, why does God give you strength? To protect the weak. Why does God give you a privilege so you can use it to serve others? Why does God give you health? To serve the sick. Why does God give you money? To serve those without it. Why does God give you life? To rescue those who are stumbling to the slaughter. Why does God give you salvation? To seek and to save the lost as his instruments. So, if you have a privilege, there's only one time you need to be ashamed of it. And that's when you just use it for yourself. That's when you just serve yourself with it. When you take them for granted. When you have the wrong response. Instead of when God gives you gifts, you say, praise you, God, thank you. You instead say, give me more, to spend on me. That's the problem. That's when you should be ashamed and you should repent. That's what we've been doing in this country. That's what we've been doing in the pro-life movement. There's a Keith Green song called Asleep in the Light. And he sings, bless me, Lord, bless me, Lord. You know it's all I ever hear. No one aches, no one hurts, no one even sheds one tear. But he cries, he weeps, he bleeds, and he cares for your needs. And you just lay back and keep soaking it in. See, that's the kind of privilege that we should be ashamed of. When we just say, bless me, God, bless me, bless me, bless me, give me, give, for me. So if you've been born, you have a privilege. You have a privilege to go to seek and to save. You have a privilege to go rescue. You have a privilege to go stand in the gates for those who are not yet born. Bradley, I do believe that a fetus is a person, that they're created equal, and that they're made in the holy image of God just like me. If you truly do believe that, then your actions will reflect it. You will treat people before they are born the way you want to be treated. You will call for them to be provided the same protection of the laws that you enjoy. You will demand the equal protection of the laws for them. You will treat Roe versus Wade as unconstitutional. You will love your preborn neighbor as yourself. And then you'll be an abolitionist. Thank you.
Hey guys, thank you for watching. To see more content related to abolishing abortion, please like and follow this channel. To stay informed or find out how you can support the work to abolish abortion in Texas, visit our website at abolishabortiontx.org. With your support, we will continue to create content to bring greater awareness to this modern-day genocide and work to mobilize Christians to do something about it. We appreciate your support and help in sharing this content with your community of friends and family. Thank you, and God bless.